We've had a couple speaker events because Zoom makes everything possible.
Yeah. Well, I was going to be coming anyway in person. Like you guys.
We haven't had a firing line debate.
Okay, so we're live on YouTube, and I am recording to the cloud, and we are about to start the webinar. Okay. So it looks like we have some attendees.
Yeah, it's going up there.
Okay, all right, I think we're gonna start. We're already a few minutes over. So good afternoon, everyone. My name is Hovik Manassian. I'm the membership director of the Buckley program. Also online, we have our publication director, Kevin Zhao, who's moderating the event with me. Welcome to the Zoom firing line debate titled The True Extent of Executive Power with Professor John Yu of University of California at Berkeley and Professor Sai Prakash of the University of Virginia Law School. Before we introduce our guests more formally, I want to take a few seconds to say some words about the Buckley program. First, for those of you who don't know, the William F. Buckley Jr. program is an organization dedicated to promoting intellectual diversity and open political discussion at Yale. We do so in a variety of ways, including hosting lectures, dinner seminars, firing line debates, and an annual conference. Our over 300 Buckley Fellows have a wide range of political beliefs, but they still stand united against the formation of a liberal-only echo chamber on campus. By providing Yale students with a forum to engage meaningfully with serious conservative thought, the Buckley program forwards its mission of a more open and more representative political atmosphere, especially at a university where the mission is the cultivating and creation of new knowledge. Buckley Fellows believe that all perspectives, including those on the right, must be heard and examined in good faith. You can learn more about the program and how to become a fellow on our website, buckleyprogram.com. All Yale undergraduates and graduate students are eligible to apply. If you're a fellow, please share this opportunity with your peers. And the deadline to apply this semester is October 15th.
Okay, and now on to our guests. Professor John Yu is the Emanuel Heller Professor of Law at the University of California at Berkeley, a visiting scholar at the American Enterprise Institute, and a visiting fellow at the Hoover Institution at Stanford University. His 10th book, titled Defender-in-Chief, Trump's Fight for Presidential Power, was published in the summer of 2020. And Professor Yu has served in all three branches of government. He was an official in the United States Department of Justice, where he worked on national security and terrorism issues after the 9/11 attacks. And next, we are joined by Professor Sai Prakash, whose scholarship focuses on the separation of powers, particularly executive powers. He teaches constitutional law, foreign relations law, and presidential powers at the University of Virginia Law School. Professor Prakash's most recent book, titled The Living Presidency, an originalist argument against its ever-expanding powers, was published in 2020. Professor Prakash has authored over 75 law review articles. Both of our guests are alumni of Yale Law School, so we welcome them back, and they both clerked for United States Supreme Court Justice Clarence Thomas.
Now I'll give a brief overview of the format of today's debate. We will give 5 minutes to each guest for opening statements, starting with Professor Yu and then moving on to Professor Prakash. Then both speakers will have 2 minutes each to respond. And then we will move to questions from Kevin and myself, and then we will give questions to the audience, and then we will end with closing remarks. Audience members may offer questions via the Q&A button at the top of their screens on this Zoom webinar. We will be following questions closely, so please submit any and all questions that you have. With that, please join me in welcoming Professors John Yu and Sai Prakash virtually back to Yale into the Buckley program. Professor Yu.
Thank you, guys. I just want to say it's great to be back at Yale without having to step foot in New Haven, Connecticut again. I swore when I graduated from Yale I would never step foot in New Haven, not because of anything having to do with Yale, but because when I was a second-year law student, I left my apartment for a few weeks to work in a summer job. And when I came back, some thieves had put a ladder all the way up to my second floor apartment and stolen every single thing in it, from knives, flatware, but they left behind the clothes that they thought were unworthy to wear. Only the unfashionable clothes were left, but they stole every single thing in my, so everything I own starts after my second year of law school. I have no possessions from before I ever showed up at Yale Law School anymore. So, and it's great to be here with my friend, Sai Prakash. We were 1 year apart in law school. We clerked for the same lower court judge, and we spent a year in an office together at the Supreme Court. And I am here to prove to you that Sai is as obstinate, stubborn, and unyielding and unreasonable as he was when we shared the office back then as he was back then. We used to argue about things all the time. And still, can I tell a story about Sai before I start? It doesn't count about my time. One day, I love this story about Sai. One day, Sai didn't show up to work. I was in the office. It was great. He wasn't bothering me in my office. He didn't show. But then it's 12 o'clock. He's not there. 1 o'clock. We're starting to get worried. We start calling his apartment, his phones. He never showed up. Finally, he shows up at 3 p.m. I said, Sai, where were you? He said, oh, I overslept. I can't believe I slept all the way. Why did you oversleep? This was a Monday. Well, Sai, what were you doing? He's like, well, Sunday, I went to get a haircut and I just passed out. I slept the whole night. I was like, Sai, how is it that you could fall asleep from a haircut? Well, I had a $5 coupon for a haircut and the place was 10 miles from my apartment. So I walked all the way to get the haircut and walked back. I'm like, Sai, why didn't you just take the subway or cab? But then it wouldn't be worth $5 anymore, would it? I would have had to pay for the public transportation. This is what I was working with for a whole year. And it's a true story. Go ahead and try to deny it, Sai. You can't, because it's the truth. He probably doesn't even remember because he fell asleep so many other times since then from getting free haircuts. That's just like number 15 in the hundreds of times he's passed out from getting free coupons. Anyway, so it's great to be here. And I really, I've wanted to come and visit with the Buckley program. I'm very proud of what you all are doing. I do have to say, if you want to bring conservatism back to Yale, good luck to you. But I think it's really important. Sai and I were members of the Federal Society when we were at Yale Law School, which has a similar mission, just to provoke open debate about important subjects. And I'm really glad you guys are doing so well. And I know a lot of the alums I've met are really happy and proud of all the good work you're doing. That doesn't mean conservatives don't disagree. And one thing we disagree about is the presidency. And that's what we're here to talk about today. I wrote this book. Where is it? Defender in Chief. See? Very attractive book. Worth many. You can't just have one. You've got to get 5 or 6. I wrote this book, started working on this book 4 years ago when Trump was running for office. And I was not a supporter of Trump's 4 years ago. I didn't vote for him. I actually was quite worried about what his relationship with the Constitution might be. The reason for that is because Trump is a populist, and populists campaign to come to Washington to overthrow the status quo. They don't like the way things have been happening. They don't like traditions and practices. The Constitution, if anything, represents the status quo most of the time. So I think I was worried that Trump, like a lot of populists, would want to overturn a lot of the constitutional ways we've been doing things. But a funny thing happened on the way to 2020. I found that Trump drove his opponents so crazy. And the reason why is not because of the Constitution, but because of his political disruptiveness, the way he relates to the American people through social media, the way he attacks opponents, the way he's running a constant campaign, the way he's disrespectful of traditions, of the way you're supposed to act, the way he overthrew a lot of consensus in American policy, both domestic and foreign. That it's his enemies that have been the ones who now want to overturn a lot of our basic constitutional structures. It's his opponents who want to get rid of the Electoral College. It's something that came up repeatedly in the presidential Democratic nomination fights. It's his opponents who are now, right now, calling on Democrats to pack the court, to add 6 new justices, increase it by 2/3 in size, because Trump wants to fill a vacancy. It's his opponents who claim that the federal government is coming into cities like an occupying military force and thrusting the country onto the verge of fascism. This is not I mean, when I read these words at first, I thought these were bloggers, but these are actually words that appear on the New York Times editorial page. It's his opponents who want to make permanent, I think, the cancer on the separation of powers of independent counsels who would use prosecution and criminal laws to resolve our political disputes. It's his opponents, not Trump, who want to create a Green New Deal, which would nationalize our energy and transportation sectors, lead to a vast expansion of federal power at the expense of the states. Meanwhile, that has left to Trump the field of defending and carrying out traditional presidential powers, relying on the arguments and claims of his predecessors, and I think trying to restore the original 18th century Constitution in our politics. And just quickly talk about two obvious cases. The first one is the Robert Mueller investigation into the Russia collusion claim. Take a step back. What was that really about? To me, it was about a conflict between a 20th century progressive vision of the Constitution and the original 18th century vision of the Constitution. The 20th century vision, which I would readily admit is the one we're living in now, is the idea that there are independent experts of government. All public policy problems are scientific, technical, and professional questions. Those people, here, insert Jim Comey, here, insert the leadership of the FBI and the Justice Department, here, insert Robert Mueller and special counsels, right? They know better than the American people who's worthy enough to be president. And they should be kept as far away and independent of politics as possible. Now, Trump, in firing Jim Comey and fighting Mueller, stood up for the 18th century Constitution that's written down and which the American people ratified and adopted, which is the Constitution only recognizes one person as head of the executive branch, that's the president, and gives him alone the duty to take care that the laws are faithfully executed. And from that, we've inferred that everybody who works in the Justice Department, in law enforcement, is ultimately responsible to the president, and he should be able to fire and remove anybody involved with that function. Or take impeachment. Again, I think you had an uprising of a bureaucracy here, the Foreign Service, that thought it knew best what foreign policy was, that it knew best how to conduct diplomacy. Remember in the impeachment, the exaltation of this idea of the interagency process, that was some kind of holy writ, and that how dare Trump challenge the results of the interagency process? Because that's the result of experts who are, again, not involved with the dirty business of politics. Trump, however, he is the one who's elected by the American people. In our 18th century constitutional vision, we elect him. He carries out foreign policy. He carries out law enforcement. He controls the people in the executive branch, the subordinates who do that, who assist him with that. And we, the voters, can hold him responsible if we agree or disagree. I think that was the bigger constitutional lesson behind impeachment. So let me just wrap up by saying that these uses of presidency have mostly been defensive. It's been Trump defending himself from assaults coming from all sides about his legitimacy. He's also used presidential power to, I think, expand his powers, but in a direction that people would not have expected. And here I'll look at the war power and the treaty powers. Trump, like the presidents before him, have claimed the right to launch hostilities without a declaration of war, without congressional authorization. He's made the claim that he can terminate treaties on his own, and he's done that a lot. You could list them on the Trans-Pacific Partnership, the Paris Accords on global warming, the Iran nuclear deal, the arms control treaties with the Russians. He's also, continued conflicts in Syria, in Iraq, and in Afghanistan. But notice what he's been doing. He's been trying to use presidential power to reduce our footprint, because while he's continuing those wars, he's trying to draw them down. He pulled out of Syria. He's drawn down sharply in Iraq. He wants to pull out completely out of Afghanistan. He's been terminating treaties which have reduced our obligations around the world. If the president never had those powers, then how can Trump do these things? If Congress really is supposed to set policy in war and treaties just like it's supposed to set policy domestically, how can Trump unilaterally change our global deployments? How can he unilaterally change our global commitments? We're living in a world actually where Congress is now the more warlike branch than the president. I think here Trump has been restoring American national sovereignty using his presidential powers and pulling us out of, I think, wrong-headed multilateral arrangements. But again, it's a use of presidential power that I think is in keeping with those of his predecessors. It's becoming under fire because people disagree more, I think, with the policies than with the constitutional allocation of powers. So that I want to stay close to the time I've been granted, so let me stop there. I look forward to hearing from Cy and hearing from all of you in the question and answers, and thank you very much for luring me back to Yale.
All right, well, it's great to be here with the Buckley Society. I'm a big fan of William F. Buckley. I used to watch Firing Line as a teenager. Remember him debating Ronald Reagan about the Panama Canal. Remember all sorts of debates. And of course, you know, he was an intellectual hero of mine. And it's great to be here with John. John has told you a fictional account of why I was late at the court. And it's fictional because he's conflating two different stories. They're both true, but they both didn't occur at the same time. So there is some truth there, but not in the way he told it. I think it's just wonderful that we're here debating this question. John's book and my book complement each other. Here's my book. Operators are standing by. Amazon is standing by. And the book doesn't really focus on Trump at all. It's not about President Trump. It's really more about what the presidency has become. And in my view, what the presidency has become is something quite different than what the founders imagined. And when you think of the original presidency, I think it had three principal facets. The president was principally a law enforcer, the chief executive of the nation, sometimes called the supreme executive magistrate. That's why he has a take care clause duty. He has to take care that the laws are faithfully executed. And that's why he was given authority to supervise and, if need be, remove members of the executive branch, right? So he's a law enforcer, he's a supervisor of the executive branch. And I think the third dimension that's not obvious from the text is that he's got some interstitial authority over foreign affairs. The grant of executive power includes authority to superintend foreign affairs where Congress doesn't have a slice of foreign affairs power, see the war power, or where the Senate doesn't have a check, see the treaty power. And I think that sort of neatly sums up what they expected of the executive, principally law enforcement, but also authority in other areas. And it was a strong executive. Don't ever be fooled into thinking they meant to create a weak executive. That's just a misreading of the history and reads the Constitution as if it were written in 1776 rather than in 1789. Flash forward 200 years and you see, I think, a remarkably different presidency. And how has it changed? Well, with respect to wars, presidents now claim the authority to wage war on their own constitutional authority. That was not true at the founding. If you read what Washington, Hamilton, Madison, and Jefferson say, they all deny that the president can engage in war without Congress first exercising its authority to declare war. This is a point on which John and I disagree. Another area of change, think of treaties. Treaties are now no longer made by the United States, at least not in a way that's consistent with the Constitution. What do I mean by that? Well, presidents, if they want to make an international agreement, either do so unilaterally, or they go to Congress and pass what's called a congressional executive agreement and then make the treaty on an international plane. And when they do that, they're no longer securing 2/3 consent in the Senate. They're just securing a simple majority in Congress. That's how NAFTA was passed, for instance. And that's how the reformed NAFTA of Trump is to be passed. That may not seem like a big deal, but the way to think about it is it's very hard to make a treaty if you need to get 2/3 consent of the Senate. It is far easier to get a simple majority in both chambers, right? And so it's therefore easier to make international agreements. And then the final thing I'll mention is the president's relationship to law execution is largely perverted. And it's perverted in several senses. At the founding, the president did not run on a policy platform. They basically ran on their resumes. They did not make a bunch of promises. The first promise I found was a promise not to run again. And as you can tell, that's not a legislative promise. But by the 19th century, they were seen as policy innovators, right? And they were quickly perceived as having a mandate to implement those policies once elected. That's not something that the Constitution endorses, because of course the Constitution does not even endorse a popular vote for the presidency. It allows the states to decide who will, how to select the electors. And early on, most states selected the legislatures, the electors themselves through the legislatures, right? They just appointed those electors. So there couldn't have been a popular mandate when most of the electors were appointed by legislatures, because in those states, the people didn't even vote. By the mid-19th century, every state had turned to popular selection, and presidents, or their candidates rather, were making promises. And those two things united to create this sort of popular mandate. So when presidents run for office on a platform, they then think they have a mandate to implement it. And the problem is they don't have, under our Constitution, legislative authority to implement their platform. They then go to Congress, they're often stymied, and that's when they turn to tricks to implement their platform. So this was true for Obama. He did a lot of things that were, I think, misconstructions of statutes in order to advance his agenda. See the subsidy of insurance care companies under Obamacare without any appropriation. And it's true for Trump with respect to the wall. There was no emergency with respect to the wall. He declared one nonetheless and was able to avail himself of authority that turned on the existence of an emergency. So there was a statutory delegation from Congress, but there had to be an emergency, and there was no emergency that the president could cite. It was the same old problem that's plagued the United States, right? The flow of illegal immigrants and insufficient funds to stop them at the border. So in the modern era, presidents, when they have a policy platform or a personal platform that runs up against existing laws, they are tempted to pervert existing laws to advance their goals. Why does this sort of thing happen? In the book, I give a number of reasons, but one of the principal reasons is the idea of a living constitution, right? My book is called Living Presidency precisely because I wish to draw upon the book by Arthur Schlesinger called The Imperial Presidency. And I wish to point out that liberals favor a living constitution. They praise a living constitution with respect to rights and with respect to federalism. They like the idea of a stronger, more robust Congress. But when it comes to the presidency, they are opposed to many aspects of the modern presidency. And one of the questions I ask is, well, if living constitutionalism is so good, why is a living presidency so bad? And I think the answer is you can't sensibly hold the position that the Constitution's meaning ought to change over time, but somehow Article 2 ought to be fixed, in stone in some way. And so my part of the book is trying to get liberals to rethink their valorization of the living constitutional project. So if I think about John's book and my book, I think one of the principal areas of disagreement is John's idea, I think, that the vesting clause of Article 2 that grants the executive power basically allows the contours of executive power to change over time. I don't believe that. I don't believe that the president has an open-ended power to respond to emergencies or an open-ended power to change statutes. So with that, I welcome your questions. Thanks so much.
Professor,
Thank you for that.
2-minute rebuttal.
And just briefly, I think Cy does touch on what really divides us. I mean, we're both originalists. We both think the Constitution ought to be interpreted based on its original understanding. And we're both students of the executive, and I think have a more robust view of the presidency than a lot of other law professors might, and legal scholars might. But I think where we differ is whether the founders intended to fix the meaning of the executive power that's granted to the president. And my view is that this is one of those clauses in the Constitution, like others in the Constitution, where the founders did not try to tie down the government, to try to limit the power of the president to a specific list, but they thought that there was a certain kind of characteristic that was the executive power. It was the power to act with energy, with speed and decisiveness, primarily to protect the country's security and to enforce the laws. And I think they would have assumed that the executive power would grow during times of emergency, during times when the circumstances called for vigorous executive, and then it would recede when you didn't need that. In the time of the Civil War, the executive's power would expand to handle the great, unanticipated, by the Constitution anyway, threat of secession. But then after the emergency's over, the power of the president should naturally shrink. I don't think that they would have thought, oh, the executive power is something I know what it is and I can write up a kind of grocery store shopping list of what it includes, because they knew that there would be challenges in the future to the new government that they could not anticipate. And so that's why we have an executive. That's why there is that innovation, is the president is supposed to be there to respond to those kinds of situations.
Professor Prakash, you may speak for 2 minutes, rebutting Professor Yu's opening.
Sure. I think I do believe that the executive power is a phrase that references things other than the specific authorities found in Article 2. So John and I are in agreement about, first, methodology. We're both originalists. Second, about the fact that the vesting clause does more than merely reference stuff in Article 2. But I guess I do conceive of the vesting clause as basically something like a grocery list, and that there isn't something at the bottom of the list which is whatever else is necessary. And I think John is almost reading the executive power clause as if it had a necessary and proper clause attached to it at the bottom. And for those of you who aren't familiar, the necessary and proper clause is this last clause of Article 1, Section 8, that gives Congress authority to enact necessary and proper laws to carry into execution all powers of the federal government. And I think John, in a sense, is reading Article 2 as having something similar. And as he notes, and as I noted earlier, we disagree about that. One thing that I will say about modern presidents and these disputes about executive power, what you tend to see is that Democrats favor a modest presidency when there's a Republican president, and Republicans favor a more modest presidency when there's a Democratic president. And I think if you read John's work and if you read my work, you will see a consistency as to our positions throughout both of these sorts of presidencies. We don't really care who's in office. We have particular views. So John is going to defend a presidential power to start a war, even when Obama's president, and I'm going to deny the authority even when Trump or Bush are president. But I mentioned this not to praise John or praise myself, but to point out that this dynamic makes it easier for presidents to acquire authority, because every president is able to cite the example of his predecessors, including predecessors of previous parties, and say, I'm just doing what my predecessor did. And therefore, if you didn't object to this action then, how can you object now? And I call this executive whataboutism. And it's a very powerful argument because, of course, if Obama did something, why can't Trump do it, right? Why would it be that Obama can do it and Trump can't? And of course, there's always some dispute about how analogous these acts are. But what's not in dispute is that this argument is made over and over again by the president and his allies, not this president, but every president and their allies, because the end result is it conduces to broad presidential power, because you're always able to cite something in the past that supports your action today.
Okay, thank you so much, professors, for those insightful opening remarks. And I want to invite our audience to submit some questions, and I'll start one off. Professor Prakash, you mentioned this executive whataboutism, and I was curious as to when do you think that started? Like, who was the first president that started doing things wrong and in essence allowed the subsequent presidents to be able to say, well, he did it, so I can do it as well?
Well, there's two phenomena, right? One is doing something wrong, and another, the actual phenomenon is that was citing some other president as a precedent for what you're doing, right? So the earliest example I've seen of this is Lincoln, actually. Lincoln says this during the Civil War. Lincoln was a Whig, and Whigs were a party that actually were wary of executive authority in the United States. And they were, the phrase, the term is drawn from British history. The Whigs were opposed to regal power. So Lincoln was a Whig, and the Whigs were opposed to Andrew Jackson. Jackson, as a general during the War of 1812, imposed martial law in New Orleans. And he was actually fined by a judge for doing this while he imposed martial law. And then he jailed the judge, and who had defied him. Much later, Democrats in Congress decided to pay the fine for Jackson or reimburse Jackson for the fine. And they did so on the grounds that Jackson had constitutional authority as a general to impose martial law in New Orleans. And so when Lincoln was president, he was criticized for suspending habeas corpus. There were people who said, you can't do this, only Congress can. And he pointed out, well, Jackson did this, and Jackson was a good Democrat, so how can Democrats criticize me for doing this? And so it's an early example of whataboutism, and it's interesting because, as a Whig, Lincoln couldn't have thought that what Jackson did was permissible. And in fact, what Lincoln did had no precedent in American law other than Jackson. And not only did the judge condemn Jackson, but his president condemned Jackson. Madison said that what you've done, Jackson, can only be done by Congress. Even I can't do this. So this phenomena has deep roots, but it makes perfect sense, right? It sort of trades upon some equality principle, right? If my opponents have done something, why can't I do this? But of course, the legal question is whether or not what you've done or what they've done is constitutional, not merely whether it's been done before. Having said that, the courts and the executive branch take great solace in the fact that if something's been done repeatedly, it's more apt to be found to be constitutional.
Okay, I just want to give Professor Yu a chance to respond if you wish to respond to Professor Prakash's remarks on Hovik's question.
You're
I
Professor
muted.
Yu.
don't really have a response, but I'd like to pile on if I could in the finest traditions of Yale football. So actually, if Cy, it's not that Lincoln is really the first example of where I think Cy would have to say a president's done something unconstitutional. What about a lot of other things that presidents did very early on, like the Neutrality Proclamation by President Washington? Right? There's nothing in the Constitution that says the president gets to set foreign policy or decide the position of the country, right? And here, the position that will be neutral in the Napoleonic Wars. So I think Cy, Phil, believes that Washington could issue neutrality, as I do too, because you look at the executive power. What does the executive power include? It includes the power to set foreign policy. Why does it? Madison and Jefferson thought that it was actually legislative in nature. Right? They say the power to decide whether the country's at peace must be inferred from the power to declare war. So the power to be neutral must be a power that Congress also has. And I think you look at the arguments of Alexander Hamilton, and this, neither Cy or I made up this approach to interpreting Article 2. It's made up by Hamilton. And Hamilton says there's two different reasons why Washington could issue the Neutrality Proclamation. Now, one is, he says, the executive power. Executive implies control over foreign affairs. But he also says the executive is better suited as an institution to carrying out foreign affairs because it is one person, where that person can act quickly and decisively in response to fast-moving events abroad with very, very high stakes for the country. It's not just that the founders thought, oh, well, we can look at the word executive. We have our ye olde 18th century dictionary, and under executive, it will say foreign policy. I don't think it's just that. I think when you look at what Hamilton says, both in the Federalist Papers and then later, it's both that plus a functional argument that the presidency, by the nature of its construction, is better suited to do certain things for the country as a whole.
Thank you for those responses, professors. I just wanted to take this chance to remind the audience that they can submit questions via the Q&A tab at the top of their Zoom screens. But in the meantime, I'd like to pose a question to Professor Yu. Professor Prakash has in the past raised the point that Congress is given the power to grant letters of marque and reprisal, a power much less consequential than starting and waging a war, a full-scale war. So if you could please explain why the framers would give Congress these powers instead of the president, if the president were empowered to prosecute a war successfully without congressional authorization.
So let's take a look at that constitutional provision. I'm sure all Yale Buckley students have their Constitution ready at hand. So it's in Article 1, Section 8. Oh, it's right near these unimportant clauses about the Electoral College. We can skip those by. Those are not important these days. Who even reads those? Right, so it says Congress shall have power to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. So people who think Congress controls the start of hostilities say, well, those are all the ways people in the 18th century would have referred to starting a war, right? Declaring a war, letters of marque and reprisal, these people say is everything short of a formal war. Well, is there somewhere else in the Constitution they also talk about hostilities and they don't repeat this hackneyed language of declare war and grant letters of marque and reprisal? Well, if you turn the page of your Constitution to Article 1, Section 10, it's just another page away. It says, no state shall, without the consent of Congress, right? This is great. It says states can act here cannot act unless without the consent of Congress, go through all the other stuff. And it says, engage in war unless actually invaded or in such imminent danger as will not admit of delay. I think that clause creates a lot of problems for the reading Kevin just proposed. One, if you really want to give Congress all the power over the start of war, why not just repeat that exact language? Just take out the word state and put in president. Then it would say, no president shall, without the consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay. It's actually perfect because it includes exceptions for an invasion or an imminent attack where the president has to go first, which actually doesn't appear in the declare war clause. People have to read it, pretend those things are in there. Here, they're really there. And it says clearly you have to get the consent of Congress. Or putting it the other way, if you really thought declaring war and laying letters of marque and reprisal are the way 18th century people thought you started war, it should say no state shall, without the consent of Congress, declare war or issue letters of marque and reprisal. It doesn't say that either. So if you have two provisions of the Constitution and they specifically use carefully chosen language and it's different, you assume they have different meanings. And so it seems to me the declare war language just has a different meaning than this very clear, I think, provision that talks about preventing someone from going to war unless Congress says so. So I think what that clause means to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, what do they have in common? They're about the international legal status of acts you take during wartime, hostilities, right? Declaring war gives a formality to hostilities. It's a kind of perfect war is what the 18th century international legal scholars would have called it. Granting letters of marque or reprisal mean that you have the legal authority when you're Horatio Hornblower or the guy, a master and commander, and you're going around capturing ships and attacking other countries, you have legal authority. And then of course that seems pretty clear by the third clause, make rules concerning captures on land and water, right? It doesn't say authorize captures on land. It's talking about who gets to own the cargoes and the things you seize. It's all about the international legal effect of hostilities, but I don't think that's about who starts the war domestically under domestic constitutional law in the first place. I think we have taken the phrase declare war, which has this contemporary meaning today of starting wars, and we've read it backwards into the Constitution to the 18th century where it isn't there. I mean, as I would concede, there are almost no declarations of war issued in these days. They're very rare. The British often, I think I looked this up, the British in the 100 years before the Constitution waged dozens of wars. They issued one declaration before hostilities once. Never, this just wasn't, it was not connected to the idea of starting hostilities.
Professor Prakash, would you like to respond?
Yeah, so John is a brilliant scholar, and he really got people to focus on the phrase declare war and a peace in the Southern Cal Law Review about 2 decades ago. The problem with John's
that
theory is
sigh
that
just
his
made me feel
theory
really
wasn't
old.
encouraged at the time. No, let me finish, John.
I feel old now.
The problem is that the theory that John ascribes to modernity is the theory of George Washington. It's the theory of Alexander Hamilton in the Pacificus Papers. It's the theory of James Madison in Helvidius. It's the theory of Thomas Jefferson. It's the theory of John Adams, right? So if you go back and look at what people said and what Congress did, no president in the early years ever claimed that he had authority to start a war. Washington says to the contrary several times. The Secretary of War says to the contrary several times. The Secretary of State says to the contrary. And Hamilton says to the contrary. And people said this before the Constitution as well. And the basic, I think, question is, what does it mean to declare war? And in the 18th century, as John just told you, most nations did not issue formal declarations of war. But that did not mean they didn't declare war. Every war was declared. It was either declared informally or formally. That's why an English prime minister in the early part of the 18th century said, of late, most declarations have been made from the mouths of cannons. What he meant is, if you start a war, you have declared it because you've made it clear that you wish to wage war. And so when they read the Constitution, when it was presented to the American people, people said this makes it harder to go to war because you need to go through bicamerals and presentment. And if you look at the early wars of America, think of the quasi-war. That's all done by Congress, and it's regulated in minute ways that are inconsistent with John's theory. Congress passes statutes that authorize the taking of some French ships on certain voyages, but not others. The patrolling of American ships in some places, but not others. And when ships are taken in contravention of that statute, the Supreme Court says the taking is illegal. I think something that's inconsistent with John's theory. So John is to be commended for a tight focus on what it means to declare war. And he's got a good argument about how they could have written Article 1, Section 8 by reference to the language in Article 1, Section 10. But the way to think about it is Article 1, Section 10 is trying to tell states what they can't do. Article 1, Section 8 is trying to tell Congress what it can do. It's not a limitation on the presidency, right? Article 1, Section 8 is about Congress. So this is a great argument to have, and now you need to read both books to see who you agree with.
So Professor Prakash, this one's, well, for both of you, but if you can go first. If one reads the Federalist Papers, it seems that the founders were to some degree more worried about legislative tyranny than executive tyranny. Today, we seem to be moving in the direction of the opposite problem. Did the founders get this wrong? And if so, why? That was a question from our audience, by the way.
What I would say is it's clear that the founders are most concerned about legislatures, because in that era, legislatures are the ones that are the impetuous vortices, right? If you read the Federalist Papers, it's the legislature that's usurping executive and legislative powers. I think if you were to examine each of the branches today, I think you'd find that all of them are usurping authority, right? My book is on the presidency, and so it's focused on that. And I think the presidency certainly has grown vis-a-vis Congress. But if you look at the Supreme Court, they're clearly, I think, engaged in an ongoing constitutional convention of 9 people, with 5 people able to change our constitution in various ways. So the court is also, I think, engaged in a power grab, right? They're not merely interpreting the Constitution, they're adding to it and subtracting from it, right? So if you take constitutional law, you'll find that there are constitutional rights that are dead letters because the court refuses to give them any meaning. And then there are other clauses that are greatly expanded because the court uses them as engines of overturning majoritarian legislation. And then if you look at Congress may have lost some authority vis-a-vis the presidency, right? May have lost some authority to the presidency, and I've outlined that. But they've gained tremendous authority vis-a-vis the states, right? The idea that Congress had a general legislative authority is belied by any fair-minded reading of the Constitution. But that's precisely what we have today, right? The court has read the Commerce Clause in absurd ways to suggest national authority over anything economic. But it is not the economic clause, it's the Commerce Clause. And it's not even the Commerce Clause full stop, right? It's the interstate, Indian, and foreign Commerce Clause. It is not the domestic intrastate Commerce Clause. So every branch has usurped authority. It's not just the presidency, but John and I can only discuss one thing at a time. And so I'm railing against the presidency and John is ably defending it. But no one should leave this talk assuming that the presidency is uniquely untethered to the Constitution. I think all three branches have in some measure gone beyond their authority. And of course, that's exactly what the anti-federalists predicted, right? There were people who said Congress will, basically assume general legislative authority. The president will be something of a monarch. And there were anti-federalists who said the judiciary was too independent. And you might think that they were right.
Professor Yu, would you like to add anything to that?
Sure. I know there's a difference between what Cy and I think, but I'd make the difference, maybe a difference with him about enforcement. So if we think that there's a separation of powers and that it contains the executive and legislative and judicial branches to certain roles, the question is, how do you identify and enforce the limits? And so I think one thing Cy's book seems to argue is that you can come up with a defined boundary from the founding. And then theoretically, I guess you go to court and you get the court in the right kinds of cases to enforce that line. I think in the Federalist Papers, the defenders of the Constitution have a different view in mind. They talk about ambition counteracting ambition. This is something Cy and I have argued about. Does Trump even have to be defending the Constitution? Does it require him to care that he's defending the Constitution? My argument is that the founders didn't expect or need the president to be thinking all the time about the Constitution. Instead, what the Federalist Papers describe is each branch pursuing its own self-interests. And by pursuing their self-interest, they will come into conflict. And the founders wanted the branches to fight all the time. And they wanted them to struggle over which power was theirs or not. And that it was that constant fighting that would check each other, check the government as a whole, and preserve individual liberty.
Okay, thank you. We have a question from an attendee that says, starting now, Eric Nelson has recently argued in the Royalist Revolution that the American Revolution should be understood as more than a revolution against the British Parliament, but rather than the Crown. In some cases, founders seem to believe that King George III did not do enough to restrain a legislature out of control. How does this affect your thinking on modern unitary executive theory? And Professor, you may start.
Why don't I take a crack at that? I guess it does in this sense. I think the period where Sinai Price would agree is the most important for understanding the presidency is not the American Revolution, but the period right after. So you'll often hear, and I think Nelson here is responding to this common myth. You commonly hear people say, oh, the founders would never be in favor of this kind of presidential power, that kind of presidential power, because they rebelled against King George III. Right? And the Declaration of Independence attacks the idea of monarchy. And that is, you often hear senators say this all the time. And this is just a misunderstanding of American history. The critical period is the period between the Revolution and 1787 when the Constitution is written. In fact, historians call this the critical period. And the reason why is because the revolutionaries did put all of these anti-executive ideas into practice. So my home state of Pennsylvania, the state constitution written in the time of the Revolution created a 12-member executive body that replaced the single governor. And every person on that body had to rotate off after a year. No one could get reelected, and it was picked by the legislature. These were actually genuine attempts to attack the idea of executive power. But the thing that happened that people forget who subscribe to this King George III argument about the presidency is that the people who came together in Philadelphia to support this new constitution were coming to fix things because of the problems created by the anti-executive nature of the state revolutionary constitutions. The previous question said the founders in the Federalist Papers seemed very worried about the legislative power, not the executive. That's because when the legislative power got unleashed without a check from the executive, and James Madison's a big proponent of this as well as Hamilton, it started engaging in terrible deprivations of liberty, of severe interest group politics, of the takings of property, changing laws all the time, inconstant politics. And so the founders, I think Si and I both would argue, of the Constitution sought to restore the executive to the position it had been because they needed it to check the excesses of legislative power. And so it's a mistake, I think, to read the Constitution as having this kind of anti-executive theme running throughout all of it. In fact, I think it's actually the opposite.
Professor Prakash, one of our attendees, wants to know if what you think about the recent debate of whether President Trump should fill the recently vacated seat on the Supreme Court.
Well, I mean, that's a political question. I think he has every right to nominate someone. And under established practice, the Senate has every right to consider it or not. Obviously, the Republicans are going to consider the nomination. In my book, a previous book called Imperial from the Beginning, I actually argued that the Senate has a constitutional responsibility as a counsel to the president to move expeditiously on nominations. And so this was written in 2015 before the whole fiasco with the Obama appointee or the Obama nomination of Judge Merrick Garland. So basically, if you go back to the founding, there are a number of people saying the Senate's a counsel to the executive with respect to nominations and treaties. And in fact, if you look at the Senate's proceedings, they're called executive proceedings. They're not called legislative proceedings. They have a separate executive journal. And Washington himself says evidently the Senate's a counsel to the president. And counsels had particular functions. They weren't allowed to just refuse to provide their advice and consent. They could vote no, right? But they actually had to deliberate and give an answer. And so I think the Senate's function is almost akin to the opinions clause of Article 2. The president has the right to get the written opinions of the principal officers of the executive department. That's in the Constitution. And there's a way in which that's equally true of the Senate. And there are early episodes of Washington actually going to the Senate for their advice, standing there, asking them questions and seeking their advice. So the simple answer to the question is, of course, the president can nominate someone. And under our current practices, the Senate has apparently authority to act or not, depending on its own whim. Because there's a Republican majority, they're likely to act upon it. But as I said, I think there's probably a duty. That puts me in a minority, I think, of American lawyers. I think most professors think there's no such duty, or they certainly, think that when it's a Republican president, and may think there is a duty when there's a Democratic president. But my position was made without regard to who was president.
Okay, we have time for one last question. So this is for Professor Yu. If the president should be allowed to fire anyone in the Justice Department, who would then investigate and present the president's misdeeds to the public? Without independent experts in the Justice Department, can anyone discover the president's misdeeds?
I love this question because it illustrates the way that we have all fallen to the false consciousness of this progressive Constitution. Notice the language. Who else is going to be the expert investigator to tell us about the president's misdeeds? Right? The idea that this is a matter of professional judgment and not a political act is very much this idea, the 20th century progressive Constitution. The 18th century founders would not have thought about it as something that needed expert investigation or legal interpretation. What they would have thought, which is what they did, is that they would have made it a political responsibility. And so if the president, say he commits a crime and he fires all the prosecutors who might want to investigate him, well, then Congress is actually the body that's supposed to contain him. They can use political tools, they can use constitutional tools like cutting off funds, not confirming people, frustrating the president's legislative agenda, but ultimately Congress can impeach. The House of Representatives by majority vote can impeach a president for committing a crime. And I think while he's committing crime while he's president, and I think the Senate, by 2/3, but the Senate is the trial court and can remove him. And I think Si and I agree on this. In fact, I think we wrote an op-ed together saying that this was actually the preferable response for investigating presidential misdeeds, not authorizing some Justice Department prosecutor to do it.
Just to follow up on that, a question from, does that take into account political parties, Professor Yu, that the political parties of Congress members and of the president might, skew their views and think that certain crimes are not actually crimes?
Well, I certainly think political parties have changed the way the Constitution works, and you certainly see that in the impeachment crisis we already had, where you had, I think, in order to impeach President Trump, Democrats had to persuade 20 Republican senators essentially to change their vote, their likely votes. But this is not to say, I think you often hear, but I'm not sure it's exactly true, that the Constitution depends on a system without political parties. I mean, the founders were, of course, quite familiar with political parties. They existed at the state level. They had them when it came to supporting for or against the Constitution. As I mentioned, the supporters were called the Federalists, and the people on this side were the Anti-Federalists. They might not have had the tightly coordinated and funded political parties we have today, but they had, they would have called them factions back then, and we had them almost immediately after the start of the new government. So the thing that actually parties do, it's not that they undermine, I think, the checks and balances in terms of abuse or so on. What political parties do is that they make the government function too easily. If you think about what they actually do, what Woodrow Wilson wanted them to do, who's the guy, I think, who's really at the heart of the progressive Constitution, is he wanted political parties to help overcome the separation of powers. He thought the Constitution was obsolete because it made it too hard for the government to pass laws. It's designed to make it difficult for the government, the federal government, to pass laws and exercise power. What political parties do is they allow the legislature and the executive branch to coordinate their activities to reduce the likelihood they'll fight rather than expand them. So I don't think political parties undermine impeachment. I think it's just a natural way people organize themselves in politics.
Mr. Prakash, would you like to respond?
I mean, I kind of agree with John. I believe the president's in charge of law execution, including prosecutions. The president's the chief prosecutor. And it follows that there can't be any independent prosecutors because the executive power is vested in the president, and Congress doesn't have authority to redirect it elsewhere by statute or otherwise. So there is this sort of problem that the attendee is pointing out. And I'd say, it's just a problem built into the Constitution. There are ways to deal with it. Presidents can be prosecuted by the next Justice Department. That's clear, right? Everybody thinks that Joe Biden's Justice Department can go after President Trump, just like President Trump's Justice Department could have gone after Hillary Clinton. Presidents tend not to want to do that because they don't want their presidency to be about prosecuting their predecessor. It's bad for the country and it's bad for their presidency. So, as much as President Trump talked about locking her up over and over again, as soon as he came into office, he's like, he was very smiling and said, we're not gonna do anything to her. And it's because he realized it would be a waste of his time and just, enmesh him in all sorts of prior controversies to no end. And I suspect that's going to be true if Joe Biden wins. He's not going to want to spend his time prosecuting the president. Now, that's not true for a New York state prosecutor, right? And President Biden cannot pardon a state offense. So we might see some prosecution of President Trump later on. But my point is, it's not as if the president will go, or any president will go scot-free, because there are mechanisms of responsibility if people choose to use them.
That wraps up the Q&A portion of our debate today. Thank you to everyone who submitted a question. We will now move to closing statements by both professors, beginning with Professor Yu.
Oh, I don't really have much of a closing statement. Other than I'm right, of course, as the Q&A should have resolved for everybody. But let me, maybe it's with closing with President Trump and some of the question you're asking about filling the Supreme Court vacancy. There are several I think I think there must be some Yale law graduates who are under consideration, although the leading candidate, Amy Coney Barrett, who clerked for the same lower court judge as Sinai did, seems to be in first place, and she's a graduate of Notre Dame Law School. I personally think it's a good thing if not every justice on the Supreme Court graduated from Yale Law School or Harvard Law School, where all of them have graduated. But I think what you're seeing going on right now is a good example of what I was talking about with my book. You have a president here, President Trump, who just wants to execute the normal constitutional power here, which is to fill a vacancy on the Supreme Court. Every president who's had a vacancy on the Supreme Court arise in their last year of their term has nominated someone. And some of those have led to a Senate to confirm them. Some of them are our greatest justices. I was looking up who has been actually nominated and confirmed in the last year of presidency. And if we took the rule that some people want, which is that you can't actually approve someone, we would not have Chief Justice John Marshall on the Supreme Court, the greatest justice in American history, who was both nominated and confirmed after Thomas Jefferson had won in the election of 1800. Notice the response. The response has not been, okay, well, if you do that, well, the next time we Democrats have the presidency and Senate in the last year, we'll confirm our person. Instead, the response has been, if you do that, we'll add 6 new justices to the Supreme Court. Now, it's perfectly constitutional for Congress to do that, but I would say it's a terrible, terrible destruction of constitutional norms to start playing around with the size of the Supreme Court until you get the results you want out of it. It would, I think, really lead to the politicization of the courts and ruin their integrity and independence. And I think shows again that Trump just drives people so crazy they're willing to entertain the destruction of constitutional norms and practices that have really made our government succeed for the last 200 years.
Okay, thank you for that. Professor Prakash, if you'd like to take this opportunity to offer any closing remarks or answer any unanswered questions from before.
I think this has been a tremendous debate and been fun. You need to buy this awesome book and you need to buy John's awesome book. I will say that people who didn't have their questions answered should feel free to email me. There are some anonymous attendees who've had questions and I'm not sure why they're anonymous. These questions seem harmless. You can put your name to them to me and send them to me. This has been an utter delight, and as I said, I'm very grateful that the Buckley program invited me. So thank you so much.
So let's take a moment to thank our guests, Professor Yu, Professor Prakash. It was such a pleasure to have you, and I think we'll end it here. Kevin?
Yep. Thank you so much for coming, everyone.
Thanks, guys.
Thank you.